तो भाई टेक्निकल का सभी सीख लो, अच्छा है। फ्यूचर में कभी भी जरूरत पड़ता है। मैं भी सीख लिया था क्या कुछ। हाँ हमारे राइट काफी आगे उसको म्यूट ऑन कर दो।
मेरा है कि तो मेरा ये जैन में होने बेटा वो कुछ टेक्निकल प्रॉब्लम था, जैन हो जावा था। टेक्निकल प्रॉब्लम था, जैन हो जावा था आपको।
नहीं नहीं लाइव शुरू स्टार्ट हुआ लाइव तो एक वीडियो पे क्लियर क्या बोला तो ना लाइव
तो फुल हो जाता।
Good morning, everybody. Is it audible? Please message me. Good morning to all of you. Yes, sir. Yes. Are you able to join? Yes. Shall we start the topic? Fundamental rights. Okay. Thank you very much. We'll continue from the last video. It means that from the last class where we had completed. It is topic fundamental rights, right? Okay, right. Thank you very much. We'll start the topic fundamental rights. So we're talking about the Article 20 now. Okay, in the last class, we had completed the Article 19, right to freedom of speech and expression. We completed the Article 19 and we'll move to Article 20 now. Okay, what is this Article 20? Okay, right. So in this article, we're talking about some important terms. What are those terms? There are 3 subclauses in this article: clause 1, clause 2, and clause 3. Okay, what is this 3 subclauses? Clause 1, clause 2, and clause 3, right? Okay. So 20 clause 1, this article talks about, just I'm telling you the important terms: no ex post facto, no ex post facto legislation. Okay, what does it mean? No ex post facto legislation. Okay, number 2, no double geopardy, no double geopardy. Okay. Number 3, no self-incrimination, or no testimonial compulsion, no self-incrimination or no testimonial compulsion. Okay, these terms are very, very important. Just try to understand these terms. Sorry. Okay. No ex post facto legislation. Okay, 20 clause 1 says that no ex post facto legislation, no double geopardy, no self-incrimination, no testimonial compulsion. Sir, what does it mean? The first article talking about 20 clause 1, no ex post facto. What is the meaning of ex post? First of all, try to understand the term ex post. Ex post facto legislation. Ex post means no person shall be punished according to the law which is in commission. So what does it mean? It means that I'm going to tell you in the simplest form. Suppose a very important law enacted by the parliament, that is triple talaq. Okay, triple talaq. Suppose triple talaq. Triple talaq in the year 2021, triple talaq law made by the parliament. Okay, so triple talaq. If you gave divorce according to triple talaq in the year 2020, that is not applicable. Okay, it means that law enforces in the year 2021, right? And whatever the crime or whatever the thing you had committed before the enforcement of law is not applicable. Okay, it means that whenever the law enforces, okay, at the commission of the time, from that time onwards, the law came into force, not the backdated. Suppose in the year 2021 law enacted, the law will not be implemented from 2020. It will be implemented from 2021 itself. Okay, so it means that any law, you think that this is in criminal laws. Okay, this is in criminal. It's not civil. I'm talking about now criminal. Suppose criminal. You're talking about the criminal. Recently, Government of India enacted Nirbhaya Act. Okay, Government of India enacted Nirbhaya Act. Okay, so Nirbhaya Act enacted. Say, let us think that. Let us have that act amended. Okay, we'll go for an example. Nirbhaya Act amended in the year 2021. Say example 1st August. Say example 1st August. Okay. But the law will not be implemented before 1st August. It means that whatever the crime done by an accused, whatever the crime done by the accused before the law, it means that before 2021, August 31st, that law is not applicable to you. Okay, so whenever the law made by the parliament, from that date only it will implemented, no backdated. Okay, please remember the term no backdated, no backdated. Okay, the law will not be implemented from the back 1 month or 1 day. Whenever the law came into force, whenever the president gave assent, from that day onwards, law will be implemented, not from the back date. So that is the reason we are calling it as we're talking it as a no ex post facto legislation. No. Ex post facto legislation means backdated. For example, yesterday, Telangana government announces DNS allowances from 7 to 17.25 something percentage announces the last yesterday announces the increases. Okay, DNS allowances increases from where? From the increases from at present? No, increases from the past last year 2021 from January. Okay, applicable from the January 2021. Okay, applicable from the January 2021. It means that this is called as ex post facto legislation. Ex post facto legislation means law applicable from the backdated, whereas criminal laws will not applicable from the backdated. Okay, will not applicable from the back. This is called as no ex post facto legislation. Whenever the law implemented from the time onwards, from the date onwards, the commission, the act came into commission or came into force. So this is called as no ex post facto legislation, no backdated. Simply remember no backdated. Okay, are you able to understand here? Okay, right. So let us move to the next one now. Okay, next one is 20 clause 2. 20 clause 2. We are talking about 20 clause 2. No double jeopardy. Okay, 20 clause 2. No double jeopardy. No double jeopardy means no double punishments. Sir, what is the meaning of no double punishments? No double punishment means, okay, punishments, double punishments. It means that whatever the crime done and accused after convicted, all the sections came into force at a time. Suppose any convicted persons, okay, court awarded them so section 120, 420, likewise 497, likewise some sections, okay. the cheating cases. These are related to the cheating cases. Okay, so all this for this 3 months example, for this 2 years, for this 1 year, like this. So this is 3 months. So maximum is 2 years. For example, the court awarded 2 years. Right. Okay. Please mute all of you. Something Sheikh Kadir. Okay, right. So it means that from all this section, the final punishment is say 3 years. 3 years includes all the related sections. So likewise, no double punishment. Double punishments will not be there in the court of law. Okay, even the Kasab also, he had convicted for so many sections. All the sections together went for the capital punishment. So it means that no double punishments. Okay, no double jeopardy. Okay, and what is the third one? We're talking about the 20 clause 3. What is the third one? This article talks about no testimonial compulsion. Okay, no testimonial compulsion. It means that testimonial compulsion means that one should not forcibly, any police officer should not forcibly take the witness. Okay, should not collect the fingerprints forcibly, should not ask to sign forcibly. This is called a testimony, no compulsion. But anybody, one person should not be compelled to do so. Okay, compelled to do be witness. If suppose if anybody knows very well that he has not committed a crime, that person, the accused, should not ask or should not compel anybody, to be a witness. No compulsion, no testimonial compulsion, no self-incrimination. Okay, no self-incrimination. All this article related to the criminal laws. Okay, this article exclusively talk about the criminal laws. Okay, so no testimonial compulsion. Okay, no self-incrimination. Self-incrimination means one should not be compelled to be witness of his own. You should not be a witness anybody. Okay, you should not ask, you should not compel to be anybody, should not collect fingerprints, should not ask for signature. So all these things are related in the article 20. Okay, so I will repeat. The article 20 talks about first one, no, okay, no testimonial compulsion. Okay, no ex post facto legislation. Later, no double jeopardy, no testimonial compulsion. These are the 3 things which are related in the article 20. Right? Are you able to understand clearly? And let us move to the article 21. Right? Let us move to the article 21. Yeah, this is a very, very important article. Okay, article 21, 100% important article. This article talks about right to life. This article talks about right to life. Right to life. Okay, this concept is borrowed from right to life, borrowed from Japan. Right to life, borrowed from Japan. Very, very important article. Life. Your life, you're talking about your life. Right to life. This article forms the foundation stone. This article forms the foundation stone or basic foundation stone of part 3. What is the meaning of foundation stone of part 3? Foundation stone means, okay, foundation stone means basic. Okay, without this article, it is meaningless. It is meaningless to have fundamental rights, because fundamental rights are meant for a person who should be alive. Okay, not to a dead body, right? So we're talking about right to life. Right to life, borrowed from Japan. One person should have a life. Right to life and personal liberty. Okay, very, very important. This article, at any cost, 20 and 21. At any cost, 20 and 21 will not be suspended. At any cost, 20 and 21 will not be suspended at all, even at the time of emergencies also. Okay, even at the time of emergencies also. Okay, even at the time of emergencies also, 2021 article will not be suspended. Very, very important. Permanent articles. Article 20 and Article 21 are permanent articles. Very, very important, right? Okay. So what is this article talks about? Okay, what is this article talks about? Right to life. It means a person should have a life. Okay, what is the definition of right to life? Everything we are going to discuss in this class. This is a very, very important article. This article forms the foundation stone of the Part 3 of the Constitution, because in the Part 3 of the Constitution, all the articles are fundamental rights. For a person has to be lived, because a person, a living one, okay, whoever is living, the person, all these rights are applicable. For a dead man, it is not applicable. So here, and what is this article talks about? Okay, a person should have a right to life and personal liberty. Okay, this article completely talks about right to life and personal liberty. Okay. In this article, there are two important things to be noted. Okay, there are two important things to be noted. One, number one, I'm going to write on this board. Number one, the first one is procedure established by law. The first one is procedure. Listen carefully. Procedure established by law. Procedure established by law. Okay. The second one is a due process of law. The second one is due process of law. Okay. Procedure established by law, and the second one is due process of law. So what does it mean? Procedure established by law as well as due process of law. Okay. So what is the meaning of procedure established by law or due process of law? These are the two things which is there in this Article 21, right? Procedure established by law borrowed from Japan. Borrowed from Japan, right? Whereas due process of law borrowed from USA. What is the meaning of procedure established by law and due process of law? Okay. Suppose any law made by the parliament, okay, if the law will be implemented by the executives, the court will observe whether the executives follows the rules and regulations or not. That's it. This is called as procedure established. Whether the executives follows the procedure or not. Whether the executives follows the procedure or not. Because the law established the procedures. Is that or wrong? The law established the procedure. For example, IPC, Indian Penal Code 1860, there are so many laws are there. CRPC procedures are there. Whether the police personnel follows the procedure or not. That's it. Okay, the court will examine whether the executives follows rules and regulations or not. So this is very narrow interpretation. Isn't it or wrong? This is very narrow interpretation. Narrow interpretation means very mean thinking. The court will check it out whether the executives implemented. It means implemented according to the law or not. What the law says that. Okay, what the law says that. Okay, how the law enacted. What is the procedure enacted by law? Whether those rules and regulations followed by the executives or not, that's it. This is called as procedure established by law. Whereas, this is the first interpretation. Okay, first interpretation by the court. Whereas, due process of law, it means that the court will examine with the intention of the law. So what is the meaning of intention? Not only the procedure, but also intention. The law, intention of the law is very good. Okay, intention of law is very good. Okay, intention of law is very good. Whether the procedure followed it or not, it doesn't matter. Application, intention is very good, then obviously the court will pursue it. Court will maintainable. Court will examine it and make it as a right one. So in the second process, this is a broad way. Don't look at the procedure, whether the work is completed or not. Okay, somebody will look at whether the rules is followed or not. That is procedure established by law. Somebody will think that, okay, you may ignore the rules, but the task should be completed. Somebody will think in a broad way. I don't know whether to follow the rules or not, but ultimately the result to be achieved. Okay, so this is in a broad manner. If a court examines about the intention of the law, that is called as due process of law. Due process, very, very important. So one is in a nutshell, I'm going to tell you in a one line, whether the law implemented according to the rules or not, that is procedure established by law. Okay, if the law intention is good, you know what is the meaning of intention, the inner thing, the applicable intention is good, then the court will ignore the procedure followed it or not. That's it. Okay, so this is called as the due process of law. This is called as the due process of law. Okay, right? Are you able to understand what I'm telling in the subject here? Okay, is all of you clear? Okay, right? Now, sir, what is the meaning of this one, sir? Now, right? Are you able to understand now? So, but very, very important, we would like to move ahead, sir, according to the due process of law. Okay, due process of law is very, very important. So, what is Article 21 stands for? What is Article 21 stands for? Okay, Article 21 stands for, this is the due process of law mentioned in the Menaka Gandhi case. Mentioned in the Menaka Gandhi case. Sir, what is this Menaka Gandhi case? Okay, so this is very, very important case, Menaka Gandhi. What is this Menaka Gandhi case? Okay, Menaka Gandhi case. According to the Menaka Gandhi case, Supreme Court defines, very important, all of you try to listen carefully, defines the Article 21. What comes under the life? Supreme Court defines Article 21 in the Menaka Gandhi case, and later so many cases, sir, Article 21 elaborated by the Supreme Court in so many cases. What includes in the Article 21? This question came a lot of times in the UPSC examination. Okay, so we are looking about only the right to life. Sir, what is meant by right to life? Right to life includes, okay, right to life includes, I'm going to tell you the so many things in this class. No, what right to life includes? Right to life includes your right to privacy. Your right to privacy. So what is the meaning of privacy? Okay, you have some privacy. Even telephone tapping. Okay, phone tapping comes under the violation of Article 21. Okay, telephone tapping is violation of Article 21. Very, very important. It's right to privacy. Okay, and right to education. Yesterday somebody asked me the question, sir, is right to education fundamental right or not? Yes, it is 100% fundamental right. Right to education, 21A. The case study is Unnikrishnan versus State of Andhra Pradesh. Unnikrishnan versus the State of Andhra Pradesh. The State of Andhra Pradesh, right to education. Okay, it is inserted through 86 Constitutional Amendment Act 2002. Okay, it came into force 2009. Right to Education Act, very, very important. So Unnikrishnan versus State of Andhra Pradesh, that is Right to Education Act. And what includes, sir, what includes in right to life? Okay, right to marry. Right to marry. So what is right to marry? So those who cross at present 18 years of age, it means 18 female and 21 male. But the government is planning to increase this age to 21. But as of now, those who becomes a major, so everybody has the right to marry. Okay, right to marry. So this is related to Lata Singh case. Right to marry. If you are planning to marry at the age of 21, okay, if somebody restricted you to not to marry, it is a violation of Article 21. Okay, right to sleep. So right to sleep is also part and parcel of Article 21. Okay, so what is right to sleep? One should not disturb the sleeping hours of others. So what is the sleeping hours? Usually from 10 to 6. Okay, it means that after 10 o'clock, no public meetings. Okay, no public meetings, no DJs, no sounds. Okay, no band, no barat, nothing doing. Okay, if any, because this is purely a sleeping time. Okay, it's purely sleeping time. The sleeping time should not be disturbed at all. Try to remember this one. Okay, so after 10 o'clock, nobody should. After 10 o'clock, nobody should disturb the others. Okay, nobody should disturb the others. So this is called, even the mics and the sounds should not be made after 10 o'clock. This is right to sleep. Okay, the next one is what includes. These all questions came in the UPS examination. Right to speedy trial. What is the meaning of right to speedy trial? Speedy trial means, right to speedy trial means, it means that the cases should be done in a very speedy manner. Okay, usually the criminal cases not more than 3 years, and there's a time bound to some cases. Okay, the family courts, the not more than 3 months, there's a time bound, because the speedy trial in India is very complicated because there are so many cases pending. So nearly 3 crores cases pending in the different courts in our country. It's very difficult, but government is trying to implementing the speedy trial. The next one is right against public hanging. So what is the meaning of public hanging? Okay, we are not living in a society just like in there are so many countries. Those countries, they are the accused, the convicted people. Okay, the convicted people, when publicly they are hanging. So that is not there in our country. In our country, there is no public hanging. Okay, right to decent environment. Right to decent environment. Okay, so wherever the environment is there, wherever you are locating your surrounding, your residence, your living places, all the spaces should have a decent environment. Okay, and right to, very important, right to intercaste marriage. Okay, right to intercaste marriage. Okay, this is also comes under the Article 21. Okay, right to free legal aid. Right to free legal aid. Okay, free legal aid means, okay, the government should provide free legal aid. Okay, you will have seen some the PPs and GPs, public prosecutor and government pleader. PP for the criminal case and GP for the government civil cases. PP, GPs, and every court also there is a provision of free legal aid. Okay, and next one is right to living relations. Okay, right to living relation. Nowadays the living relations are becoming popular in our country because the court permitted that one can have a living relation. Living relations is nothing but without marriage also you can stay together. Okay. So likewise, you have so many things: right against public hanging, right to intercaste marriage, right to free legal aid, right to living relations, right to marry, right to travel abroad, right to right to travel abroad. So this is what the Maneka Gandhi case, the passport case. Right to travel abroad, one can have a right to travel abroad. Okay, after crossing the major, you have every right to go anywhere. Okay, so likewise, you will have a n number of things. So far, I have discussed nearly some. Okay, right to privacy, right to education. Okay, right to sleep, right to marry, right to speedy trial, right against public hanging, right to decent environment. Okay, there's so many things, and right against handcuffings. Right against handcuffs. Handcuffs means, you know very well, handcuffs, the police person will carry the handcuffs right around. Okay, likewise, and what else? Right, right against, right against custodial harassments. Custodial harassments. Okay, in custody, the police people will make so many harassments in the custody, the police custody. So all these things are comes under the Article 21. This question came in the examination. Once examination, they called it right to privacy is in comes under which article? That is Article 21. Right to marry, right to intercaste marriage, right to living relations, right to free legal aid, right to travel abroad, right against handcuffing. There's so many things. Right to free legal aid, right to speedy trial. Okay, right to speedy trial, Okay, right to sleep. Okay, so right to decent environment wherever you're locating. So right to education. All these things are forms. So there are so many things. So really, approximately 20, approximately 20, 21, 22 things are there. All these together forms the Article 21. So any textbook, if you go through the any textbook, so you will come to across all these things. Okay. Custodial harassment is also very important. Nowadays, police people harassing the accused personnel in the custody. These are all things not there now. If it is done, it is against the Article 21, violation of the Article 21. Clear, all of you? Okay. So these are the things to be remembered in the Article 21. The very, very important thing is Maneka Gandhi case. According to the Maneka Gandhi case, okay, according to the Maneka Gandhi case, Supreme Court defines the Article 21. And there are two important things to try to remember. One is procedure established by law. The other one is, okay, the other one is due process of law. Procedure established by law means it is the very narrow-minded, whereas due process of law means it is broad-minded. Okay, the intention is very, very broad. Okay, clear all of you? Okay, so any questions so far? So did you understand the article 21? Okay, okay, very, very important, very, very important article 21. Okay, so please message me so that I can move to the next most important article. So at any cost, at any cost, this article is not suspended, even at time of national emergency also. Even at time of national emergency also, this article will not be suspended, right? Right. So your classes start at usually start at 10 o'clock itself. Okay, today 10:03, Article 20, right? So already completed Article 20. So this article talks about today's morning class. I completed Article 20. So 20 means I told you in the beginning. 20 means the first one, no testimonial compulsion. Sorry, no ex post facto legislation, no double jeopardy, no testimonial compulsion. Okay, no ex post facto legislation means no backdated, right? No double jeopardy means okay, no double punishments, right? No testimonial compulsion means forcibly one should not collect the witness or forcibly ask somebody to be a witness. This is the Article 20. Okay, please go through. So my videos. Right, shall we move to the Article 21? Sorry, 20 completed. We'll move to the Article 22. Right, we'll move to the Article 22 now. Clear, all of you? Article 22. Okay, Article 22. This article talks about the prevention of detention in certain cases. It means that this is purely criminal cases we're talking about. Prevention of detention in certain cases, right? Okay. Sorry. Is it okay, all of you? Is it okay? Right? Is it audible? So please text me. Article 22. We are going to discuss the Article 22. Thank you very much. We'll move to the Article 22 now. So what is this? Okay. Right. Thank you. We'll move to the Article 22 now. This article talks about the prevention of detention in certain cases. Prevention of detention in certain cases. So what does it mean? Prevention of detention in certain cases. It means that. So very important thing. All of you try to listen carefully. So it means that what is this article? There are so many subclauses out there. I'm not going to tell you subclauses because first one, there should be a reason for arrest. There should be a reason for arrest. Okay, so whoever committed a crime, only those persons who are committed a crime must be get arrested. Okay, and there should be a arrest warrant. There should be a arrest warrant. Okay, there should be a reason for arrest. There should be a arrest warrant, right? Reason for arrest, and there should be a arrest warrant. And very important, whoever arrested must have right to consult their own lawyer. Must have right to consult their lawyer. Consult their lawyer. Okay. Must have right to consult their after police personnel arrested anybody. The accused person must have right to consult their lawyer. And one more important thing is here. Okay, one more important thing is here. Arrested person must produce nearby magistrate within 24 hours. Very important. Arrested person must produce nearby magistrate. Okay, what is the meaning of nearby magistrate? Nearby magistrate within 24 hours. Nearby magistrate within 24 hours. Okay, arrested person must be produced nearby magistrate within 24 hours and excluding journey time. Very important, excluding journey time. Suppose arrested person arrested somewhere very far away from the court. Okay, excluding journey time. The court distance is nearly 2 hours from their police station. So those journey time will be excluded. Okay, so very important. Even for the small cases, whatever the case may be, if a FIR is booked, all these must follow. These are the criminal related cases, not for the civil cases. Okay, there should be a reason for arrest. There should be a arrest warrant. Arrested person must have right to consult their own lawyers. Okay, arrested person must produce within 24 hours. Nearby magistrate. Okay, nearby magistrate means any magistrate means a district court, any court, excluding journey time. So what happens if the court judge is not there? What happens if the judge is not there? Means they follow the protocol. Okay. If the judge is not there, then they will move to the joint collector, district collector, joint collector. If district collector not there, joint collector or additional collector. Okay, if additional collector is not there, deputy collector. If deputy collector is not there, they will go for the MRO. Okay, they will present the accused person to the nearby MRO office. An MRO will give the police custody for 2 or 3 days. If it is a holiday, suppose a person arrested Saturday evening. Okay, Saturday evening, the court is there is no court. All left, even the district collector, everybody is not in the town. So at least the MRO will be there. They will go for the MRO. The police person will go for the MRO and ask for the give for police custody for 1 day or 2 days, depends upon the time. Okay, so this is what the Article 22 talks about. The preventive detention. Detention means okay, there must be a reason in certain cases. And very important here. Based on this article, the PD Act enacted. The PD Act, Preventive Detention Act. Okay, the PD Act means without any reasons also the police personnel can be arrested. Okay, in the CRPC, the police personnel arrested can be arrested even common man also. without giving notice also. Okay, without giving notice also, the police personnel can take it into custody anybody. Okay, so that's the reason. I'm sorry. So that's the reason this article says that there are some protection to the accused person. Why a police person are arrested? What's the reason behind it? But PD Act says that the police personnel can be arrested anybody, preventive detention. Okay, and very important, the arrested person after convicting only, okay, the punishment should be implemented. After convicting means the court should award that so and so section, the accused person is convicted. Okay, so these are the things to be remembered. I suggest you to remember simply. I suggest you to remember there must be a reason for arrest. Arrest warrant must be produced, and very important, if a lady is going to be arrested, a woman is going to be arrested, women police must be accompanied. Okay, as well as police must be in the uniform, must show this identity and the reason for arrest and arrest warrant. After getting arrest, the accused means not yet convicted, accused person shall have a right to consult their own lawyers. Okay, so whoever got arrested within 24 hours, very important, within 24 hours must be produced nearby magistrate, excluding journey of time. So these are the things to be remembered. Okay, so this is the article. This is Article 22. This is Article 22, right? So any question? Yes. What if the accused is in abroad? If the accused is in abroad, the police personnel will go to the abroad or through proper channel. Okay, or to proper channel, try to bring. Okay, try to bring to our country. And what happened exactly? For example, Abu Salam. You might have heard the name Abu Salam. Abu Salam is in Portuguese. Okay, Abu Salam is in Portuguese. Okay, India and Portuguese made an extradition treaty. India and Portuguese have the extradition treaty. So extradition treaty means extradition. Extradition treaty means okay. Extradition, that's what I'm telling. Accused means is nothing but the FIR. After booking the FIR, if accused went to foreign country, best example Abu Salam is a Portuguese, the foreign country, India and that country should have extradition treaty. Extradition treaty means that whoever Indians committed any crime and moves to other country, if that country made an agreement with India, those accused person in their country must be given back to our country. Likewise, any Portuguese, for example, India, Portuguese made an extradition treaty, right? If any Portuguese persons made a crime in our country, that person will be given back to the Portuguese. This is what the extradition treaty. India and so many other countries enacted this treaty, and Abu Salam is one of the best example. Portuguese authorities handed over Abu Salam to India, and according to the law, Abu Salim got punished. Okay, even the FIR broke everything. Okay, right. So this is the Article 22. So any questions? We'll move to the Article 23 and 24. We'll move to the Article 23 and Article 24. Okay. What is this Article 23 and Article 24? Article 23 and Article 24. Right? Right against exploitation. Right against exploitation. These articles 23 and 34. So very, very important, right against exploitation. Right. Whoever it may be, Zuveria, your doubt is for normal people or whoever it may be. Yesterday I told you Article 14. Article 14 talks about whoever it may be, from the Prime Minister onwards to the common man. Okay, if ever he has whatever he had committed the crime, that is in the court of law, the punishment, that everything is same. Everything is same. Right? even for the political people. Okay, everything is same. Everything is same. Okay, right. We'll move to the next one. That is, I will allow you to please, all of you, those who are in online now, all of you write some doubts in your one separate sheet and ask me the doubts after completion of the class. Okay, after completion of the class, ask me the doubts. Clear? So that the class will go in the right direction. Okay, I will clear all your doubts at the end of the class. Right? What is this Article 23 and Article 24? Very, very important. Article 23 and Article 24. These two articles are, first of all, they are not self-executory. What is the meaning of not self-executory? Not self-executory means these articles will not came into force automatically. Okay, will not came into force automatically. No automatically came into force, because for these two articles, the Parliament should make a law for implementation. Law for implementation. Okay, law for implementation. Right? So, Article 23 talks about, very, very important, listen carefully. Article 23 talks about right against exploitation. There are two articles deals about. One is 23 talks about, this article talks about men and women, or any person, men and women should not be made as a commodity. Should not be made as a commodity means men and women buying or selling. Commodity means we can buy or sell. Buying or selling of human beings is prohibited. Buying or selling of human beings. So what does it mean? Buying or selling of human beings are prohibited. Prohibition of any human beings. Buying or selling like goods. Like goods. Okay, what does it mean? This is called as exploitation. Why if the human beings are buy or sell? Why the human beings are buy or sell, particularly the women's will buy, or somebody will buy, somebody selling, is nothing but the flesh trade or nothing but the prostitution. Okay, so many women sold to this the agents, many women sold to different persons for the, nothing but the prostitution. Okay, so this is very important terms I'm using here. There should not be any forced labor. There should not be any forced labor or beggar. Forced labor or beggar. It's not beggar, it's a beggar. Okay, forced labor, beggar. What is the meaning of forced labor and beggar? First of all, I'm telling this article, men and women should not be trafficking. Trafficking is prohibited. Trafficking of human beings. Okay, voluntarily you can move anywhere, but compulsorily, forcibly, one should not allow, one should not trafficking the human beings. Buying and selling of human beings are prohibited in this article. Okay, and very important here, forced labor. Forced labor, what we call this in our language, this is called as vetti chakiri. Vetti chakiri means more work, less payment. Okay, more work, less payment. You are doing a lot of work, but this less payment. This is beggar means involuntary work without payment. You are doing work, but no payment. Okay, you are doing work, no payment. This is all called as exploitation. This is all called as exploitation. Exploitation means whatever you are doing the job, you must get the fair remuneration for the so and so job. If you are doing more job and less pay, or if you are doing any work without payment, is nothing but you are exploited. Is nothing but you are exploited. Okay, you are exploiting. You are exploiting. Okay, even sometimes at your home, our parents, particularly mother, usually tell this words vetti chakri. I am doing vetti chakri at home. Vetti chakri means more work. Just I am labor, like I am doing the work. I am not getting satisfaction. But this is common words vetti chakri, and very, very important here. I am telling you the trafficking. The trafficking of human beings is prohibited. The trafficking of human beings are prohibited. Okay. So usually in Telangana, what happens exactly, sir, in Telangana, particularly in Andhra and in our states, okay, you might have heard this word Jogini, okay, Devadasi. Did you heard this word Jogini? And there was a system. Okay, Jogini. So Jogini means young adolescent women is marrying to God. Okay, marrying to local deity, and the entire village community made her as a prostitute. Okay, use her as a prostitute. So this is called as Jogini. Whereas Devadasi means temple dancer. Once a Devadasi had a temple dancer. Okay, once a Devadasi had a very high prestigious, but later Devadasi also becomes more or less like a Jogini. Okay, more or less like a Jogini. This is nothing but the prostitution. The women were marrying to a deity, or women were dedicated to the temple. Okay, for the needs and satisfaction of the village entertainments of the people. So all these things are prohibited. Okay, all these things are prohibited. So according to Article 23, no women's, okay, no women's, anybody, okay, anybody at any form, in any form, the Jogini or Devadasi or Vettichakiri, forced labor, Bhegar, all these things, okay, one should not exploit the others. So usually the Joginis are usually belongs to SC community. Even now in Telangana also, there are approximately some 50,000 Joginis are there in the Telangana. So you can see all these things in the YouTube channel. So what is the Jogini system, what is the Devada system? Because this is there in your Telangana movement also. In the Telangana movement paper also it is there. Whereas in the Telangana ethics chapter also it is there. Okay, the Jogini system, Devadasa system. So if anybody follows the Jogini or Devadasa system, or forced labor, or Vettichakiri, or Bhega, or all these things violates which article? Violates the Article 23 of the Constitution. So that's the reason the government of Andhra Pradesh abolition of Devadasa system, abolition of Jogini system. Okay. Forced labor abolition, Vettichakiri abolition, all these acts is implemented now, even though this exploitative system is still in continue in Telangana, Andhra Pradesh, many parts. Okay, many parts of the nation is continue. Okay, this is called as this is very important of Article 23. Okay, and very important in the Article 23. I'm going to tell you in the Article 23. In the Article 23 also says that sexual harassment of women, at working places, okay, of women at working places violates this article, are prohibited. Working places are prohibited. So whoever women are working in the any working places, okay, whoever women are working, the sexual harassments of women at working places are prohibited. Okay, are you able to understand? So according to which judgment says that it is violative of Article 21, according to Vishaka versus State of Rajasthan. Vishaka versus State of Rajasthan. Okay, very, very important. According to Vishaka versus State of Rajasthan, if a woman is harassed sexually, physically, morally, any type of harassment, okay, sexual harassment of women at working places violates the Article 23. Not only Article 23, the judgment says that even the 15 article, 21 article, and 23 article violate right to life and personal liberty and discrimination, as well as this article. These three articles are violated. A lot of times in the examination, they asked one question: sexual harassment of women at working places prohibited. According to which article violates it? It violates the Article 23. The government of India in the year 2013 enacted one law also. If anybody commits a crime, of anybody harassed a woman at working places, so it will be punishable. It will be cognizable, non-confrontable, and punishable. So this is the Article 23 talks about. Okay. Let us move to the Article 24. This article talks about, the 24 article talks about, this article talks about, okay, prohibition of children, prohibition of children, prohibition of children in hazardous working places, okay, in hazardous working places, in hazardous working places. Okay, so in mines, just like mines, in factories, wherever the working places, mines and factories, the children. So who are children according to this one? Below 14 years. Below 14 years are children. And very important, I told you just now, I've told just now in Article 21A, okay, 6 to 14 years of children, free and compulsory education, free and compulsory education. So this is the Article 21A. So what is the age here? 14 years. This is also 14 years. So below 14 years children should not be work in any hazardous working places. Try to remember this one. Below 14 years children. Okay. Below 14 years children, no children should not be work in any mines or factories or any hazardous working places. And very important, according to this one, government of Supreme Court asked the government to enact one committee. The committee name is Guru Padaswamy Committee. Okay, so what is this committee name? Guru Padaswamy Committee. So based on Guru Padaswamy Committee, okay, based on Guru Padaswamy Committee, the government of India enacted Child Labor Prohibition Act. You might have heard all this one. Child Labor Prohibition Act 1986. So what is the meaning of Child Labor Prohibition Act? No children should be worked. Children means below 14 years of age. Nobody should be worked in any places. Okay, if any child is working, please mute yourselves. Okay, if any child is working, right? If any child is working below 14 years, it means it's violative of the Article 24. Okay, so based on the Guru Padaswamy Committee, based on the Guru Padaswamy recommendation, the government of India enacted the Child Labor Prohibition Act. Whoever the child means the 14 years. From 14 years to 18 years, we can work. The child can work anywhere, but subject to some restriction also there. Okay, so no children is supposed to work in any hazardous working places. And if anybody hired a children below 14 years, it will be punishable. Minimum 3 months, it may extend it to 6 months, or extended continuously repeating the same thing. It can extend up to the 2 years also. Okay, punishable with fine also. Okay, this now exploitation. The child should not be exploited. Up to 14 years, no child should be exploited. The 14 years meant for the child should read. The child should physically should be grown. Okay, the mentally should be developed. The cognitive development. All these things are very important, right? Right, clear all of you. So, right against exploitation. One is Article 23 talks about the women, and 24 talks about the children. Okay. Right. We'll move to the next important article. Okay, the next important article, that is I'm going to type here to get a good view. Okay, I'm going to type here to get a good view. Okay, what is this one? This article talks about the freedom of religion. The freedom of religion. Okay, so Article 25 to Article 28. Okay, this is the next one. This is the next one, the freedom of religion, right? Is it clear, all of you? We'll move to this article, the freedom of religion. We're talking about the religion article. Very, very important. Listen carefully. Religion article. The question came a lot of times in the examination. Okay, Article 25. What is Article 25 now? Okay, we're talking about Article 25, right? What is this Article 25? Yes, we'll go for this Article 25. This article 25 talks about, okay, this article talks about freedom of religion. Freedom of religion means one can have one can have right to profess, practice, okay, profess, practice, or propagate, okay, profess, practice, or propagate, or anything. It means that you can profess your religion, you can practice your religion, you can propagate your religion, but based on a conscience. I'm using the terms here now. Try to remember these terms. Okay. So I told you in the secularism, India is a secular country, right or wrong? India is a secular country. Okay. One can have your own religion. You can practice any religion, right or wrong? You can practice any religion. You can profess any religion. You can propagate any religion. You can propagate any religion. Okay, based on conscience. So all these terms mentioned in Article 25, very important. Okay, very important. Okay, based on your conscience, you can profess, you can practice, you can propagate your religion. Okay, one can have a right to propagate any religion, one can have a practice. It means that the state allowed the citizen to take up any religion, to practice any religion, to profess any religion, to propagate any religion, but subject to public subject to public order, morality, okay, public order, morality, health. So all these terms mentioned in this article only. So what's the meaning of all these things? Okay, I think you might have seen some old black and white movies there. Some sorcerers and black magic. They've done some what do you call that one? Dedication or sacrifice. Themselves they sacrifice. Okay, that is not right. No, that is illegal. At the time they practices, it means that subject to public order, subject to public health, public morality. So all these things to be taken care. So you can, based on your conscience, you can leave your citizen, you can join in any citizen. It will not at all problem. Suppose you belongs to one religion. If you want to leave the religion, go into another religion. You can practice another religion, no problem at all. Okay, you can practice, you can profess, and your religion is important. You can propagate it to it. You can spread your religion, no problem at all. But only thing is subject to public order, subject to morality, subject to health. So what is the meaning of all these things? It means that one should not disturb the other. Suppose I have a religion, so I am very much religious, sir. So I want to spread my religion. It means that you should not kept loudspeakers after 10 o'clock. Is it possible to propagate the big noise with the big sounds? You should not disturb the others. There is some time. There is some time. It means that is called as the public order. The public order says that after 10 o'clock you should not use any loudspeakers. Okay. The public order says that you should not disturb the other community. Suppose if you are religious people, you want to do some big or some any rituals. That ritual should not practice on the road. It is disturbing the others. It means that all these things. Okay. In one community, we are sacrificing some animals. Which animals we are sacrificing? You know very well. So we are sacrificing the chicken, the call as the hen or the goat. But if you sacrifice anybody, is it possible to sacrifice anybody? No, that is called as a murder. Can you sacrifice any other animal which is not permitted? This is called as public morality. The government allowed you to sacrifice the goat or anything, but not other animals. So all these things, the public morality, the public health. Sir, in my religion, my God marry more than 3 or 4. So many girlfriends are there. So it is not possible to have a girlfriends in the real life. That is unethical. That is immoral. So it means that based on religion, okay, one should not practice polygamy. This is mentioned in this article. Okay, one should not practice polygamy. Polygamy means too many marriages. Okay, one should not practice untouchability. Okay, based on religion, one should not practice untouchability. Very, very important. Okay, all are equal. We are all are equal. One should not practice untouchability. One should not practice polygamy. One should not practice black magic. Okay, black magic, witchcraft, sorcerers, no magic, nothing, nothing doing, nothing. We should not practice all these things. Okay, white magic is allowed, but not the black magic. Okay, white magic is allowed, but not the black magic. Okay, one should not practice the polygamy, untouchability, black magic, witchcraft, and anything. You should not practice all these things which is against the law. You are punishable. And very important here is, sir, can we propagate our religion? Yes, you can propagate your religion, but propagate does not mean conversion. Propagate does not mean conversion. Okay, propagation does not mean conversion according to Stanislaw case. According to Stanislaw case, Supreme Court clearly says that one can have right to propagate, but right to propagate does not mean right to conversion. You can propagate your religion, no problem, no doubt about this one. You can propagate your religion, but propagation does not mean propagation, nothing but spreading, does not mean conversion. If anybody alluring means giving some benefits. You join in my religion, I will give some benefits. You join, you follow this religion, you will get some money, you will get some this thing, you will get some benefits. If anybody forcibly or alluring, I'm using the terms here, luring. If anybody lures you to join that religion or this religion, that is against the Article 25. It's a violation of your fundamental right. Okay, so did you understand? Okay, you can practice all these things. Okay, and very important in this Article 25, one more important point is there in this Article 25. Okay, I'm going to tell you a little bit some higher standard. That is the case studies Bijo. Okay, the case studies Bijo Emmanuel case. The case studies Bijo Emmanuel case. Okay, so what is the meaning? So what happened to this Bijo Emmanuel case? Okay, Bijo Emmanuel case. Okay, if I ask you one question, sir, national anthem singing. If you are not singing the national anthem, right? If you are giving respect to national anthem while national anthem is playing, you are just silent but not singing. You give respect. You are giving respect to national anthem. Okay, that is also, if somebody forces you to sing the national anthem, that's a violation of Article 25. Supreme Court clearly says in the Bijo Emmanuel case. So what is this Bijo Emmanuel case? Bijo Emmanuel means in the Kerala there are 3 students. They are suspended from the school by not singing the national anthem. Those 3 students belongs to one particular community. They told that if they sing the national anthem, that is against their religion. Okay, in their religion there is no singing. There is no singing in their religion. So that is what the Bijo Emmanuel case says. The Supreme Court says that no person should be compelled to sing the national anthem, but you must give respect to national anthem. Okay, no person should be compelled to sing the national anthem. There is no relation between the national anthem and religion. Entirely, there is no relation at all. Supreme Court clearly states that there is no relationship between the national anthem and the religion. But if anybody compelled to sing the national anthem, it is a violation of Article 25. Okay, as well as Article 19 also. In Article 19, right to speech means right to silence also. Sorry, thank you. Right to speech means right to silence also. If anybody forces you to sing the national anthem, it is violation of Article 19 as well as Article 25 also. Right, remember this question came in the UPSC level examination also. So in the famous case studies, Bijo Emmanuel case way back in the 1986, okay, 1980s case study, this one. Okay, and one more important point I would like to bring notice here, 25 clause 2, clause B, Hindus definition. Hindus include the Sikhs, okay, Jains, Buddhist also. Hindus include Sikhs, Jains, and Buddhist also. 25 clause 2, clause B clearly says that Hindus include Sikhs, Jains, and Buddhist also. Okay, so are you able to understand this Article 25? Any questions, any doubts about this Article 25? Okay, we'll move to the Article 26. We'll move to the Article 26 now. Okay, Article 26 talks about, okay, very, very important. Article 26 talks about, right? Regarding Hindus, yeah, who includes Hindus? Hindus means, okay, Hindus means it includes Buddhist, Jains, and Sikhs also. Okay, this is there in the Article 25, clause 2, clause B. Hindu includes Jains. Jains also part and parcel of Hindu religion itself. Buddhist also, Sikhs also, all this includes in the Hindu religion itself. Okay, Hindu definition comes under the Hindu definition. Okay, religion is entirely different. Religion is the belief system, the practice system. But whereas the Article 25, clause 2, clause B defines Hindus includes Sikhs, Jains, Buddhist also. Remember these terms. Okay, right? Even though they are minorities, except Hindus, all are minorities. No doubt about this. Okay, so did you understand? Yeah, Bijo Emmanuel case is different case. That is singing the national anthem. I'm talking about the singing the national anthem. One should not compel to sing the national anthem. Okay, but you must give respect to the national anthem. That is Bijo Emmanuel. Bijo Emmanuel case. Okay, right? Okay, shall we move to the Article 26? Right. So, Article 26 says that freedom to manage the religious affairs, freedom to manage religious affairs. Okay, any religious institutions, you can establish religious institutions. Okay, you can manage it. Okay, you can manage it. You can acquire movable. Okay, you can acquire movable and immovable properties based on religion. Okay, you can acquire movable and immovable properties. Okay, this is what all this says in the Article 26 clause C. One religion can have a right to establish it, can have a right to manage it, can have a right to acquire the movable and immovable properties. Okay, in Hindu religion, okay, all this Devasthanam trust, okay, TTD Tirumala Tirupati Devasthanam. When trust is there, Tirumala Tirupati Devasthanam, TTD trust is there. In Islam, Waqf board is there. Waqf board, Waqf trust, Waqf act is also there. Okay, 1936 subject to correction. Waqf act, based on Waqf act, they can acquire the movable and immovable properties and all these things. It means they will manage those Waqf board. Okay, so all these things there in the Article 26, and based on this article, acquire the movable and immovable properties. Okay, based on this article only, 26 clause C only, the very, very important judgment. Okay, very, very important judgment, Keshavananda. Okay, Keshavananda Bharati case. Okay, what is this Keshavananda Bharati case? I'm going to tell you today. Keshavananda Bharati case versus State of Kerala. Versus State of Kerala. Keshavananda Bharati case versus State of Kerala, 1973. What happened exactly? Please remember, this is a very, very important judgment for a polity student. You must remember this case, because everything, our constitution divides into two main parts. One is before Keshavananda Bharati case, after Keshavananda Bharati case, or before 1973, after 1977. So you can understand it very clearly how important the Keshavananda Bharati case. So what is this Keshavananda Bharati case? Okay, according to the Keshavananda Bharati case, it means that the Keshavananda, okay, was the state of Kerala. In a Kerala state, they implemented the land reforms. Land reforms means, you know very well, land acquisition, land sealing act. Okay, but this trust, the Keshavananda Bharati is the head of the trust. This trust has so much of land that is possessed, possessed by the trust, and that is occupied, that is taken away. It's not occupied, it is taken away by the state government according to the Land Acquisition Act. So Keshavananda challenged in the High Court that okay, the state shall not have right to acquire or right to possess the religious endowments or religious assets, because in Article 26 Clause C, says that religious endowments or religious institutions can acquire the movable and immovable properties also. They have every right to acquire the movable and immovable properties, and no government supposed to taken away that all this property, because it is there in the Article 26 Clause C. And High Court gave favor to Keshavananda Bharati case, and this state of Kerala moved to Supreme Court, and that is the reason the Keshavananda Bharati case and the full bench, okay, the full bench of this Supreme Court for the first time, the full bench of the Supreme Court, so 13 judges gave the judgment that, okay, so Keshavananda Bharati case is very, very important, and based on this judgment, the basic structure of the constitution should not be disturbed. So every time we'll get across this statement. So Keshavananda Bharati case, according to preamble also, I told you, preamble is a part of the constitution because secular word is there. Keshavananda Bharati case clearly says that preamble is a part of the constitution. So many importance. It's a very, very important case. The Keshavananda Bharati case. Just I suggest you to remember the Keshavananda Bharati case is related to the religious. That's it. Okay. Whereas let us move to the next one, that is Article 27. So what is this Article 27? Freedom to pay the taxes, freedom not to pay the taxes. Okay, freedom not to pay the taxes. So are you paying any taxes based on the religion? Okay, you're not paying any taxes based on the religion, right or wrong? Okay, you're not paying any taxes. The government should not collect any taxes, and one person should not pay any taxes. Okay, so this is very, very important. Freedom not to pay the taxes. But if a religious institutions allowed you to have a special darshan or special token, anything, okay, special darshan or special services provided to you, you will have a special services like VIP entrance or special darshan or sitting in front of God, whatever it may be. Special darshan is there in the Hindu religion, that is not comes under the taxes. That is only comes under the services matter. Okay, so the government should not collect any taxes for the religious purpose. Okay, so now the government is not collecting any taxes. It's there in the Article 27. And what is this Article 28? Freedom of religious instructions in educational institutions. Freedom of religious instructions. Is that or wrong? Freedom of religious instructions. Religious instructions in educational institutions. Right or wrong? Okay, so there are 4 important clauses. Yeah, already I told you regarding the trust. Okay, trust, they can collect. Suppose Tirumala Tirupati Devasthanam is a trust, TTT Devasthanam trust. Okay, the trust is collecting money for the entry ticket. Okay, that is called a special darshan ticket, 500. Okay, 1500. They are charging some thousands of rupees to have a darshan of God. So that is called a service. That is not a tax. That is called a service because you are availing that service. Okay, you are availing that service, the trust or anything, any devasthanam, any board, it's a board, trust, anything, they are providing some service to you that you are paying, that is chargeable. That is called a service. That is called a service. That is not a tax. They are not called as tax. Tax means the government should provide that. Suppose you have an income tax, okay, you have a customs tax, you have a central excise, you all these taxes are there. Okay, so that is not called as taxes. Okay, that is not called as that. That is only a service. Okay, so we'll move to the next one. This is very important here. What is this one? This one talks about. Okay, this one talks about freedom of religious instructions. So what is this freedom of religious instructions in educational schools? Okay, there are four important things you must remember here. Number one, what is the first one? The first one is, okay, completely funded by government, completely funded or aided by government, completely funded by aided by government, funded or aided by government. So I assume that this is the government schools, colleges, right or wrong? Government schools, colleges, government schools and colleges. Okay, government schools and colleges, no religious instructions imparted to the people. Is it right or wrong? So many of us, I think some of you, you will, you have awareness in the government schools and colleges. No religious instructions will be imparted to the people. No religious instruction. Whatever the whoever the professor, whoever the lecturer, whoever the teacher may be, whether Hindu, Muslim, or Christian, no instruction, religious instructions is completely banned in the government schools and colleges, right or wrong? Whereas in the second case and third case, okay, this is called as the private educational institutions, right or wrong, and partly funded, partly aided or funded by the government. Sorry, partly funded or aided by the government. Partly funded or aided by the government. So you might have studied in the private educational institution that is headed by Hindu or Muslim or Christian, right or wrong? The management may be Hindu, the management may be Muslim, the management may be Christian. Religious instructions, okay, religious instructions can be imparted, but the pupil should not be compelled. Religious instruction will be imparted, no problem at all. So I went to teach Hindu schools, Muslim schools, and Christian schools also. So there, Hindu schools, at the time of lunch, they asked the children to sing this Telugu Hindu song, that is Saraswati Namasubhyam Varade Kamarupini. Okay, but the other community children is not compelled. They simply stand and give respect. That's it. A time of lunch, but no student should be compelled. Even the Muslim school also, they will ask the religious instruction will be imparted in the Muslim school also, but the other communities' children should not be compelled to follow that religion. Even the Christian missionary schools also, they will compel about their religion. They will not compel about their religion. They will mentions about the Christianity, about the Lord Jesus and everything, but the people should not be compelled to follow it. Okay, so religious instruction will be imparted, but the people means children, should not be compelled to follow it. This is second and third case. Whereas in the fourth case, the religious endowments institutions, okay, in the religious endowments institutions, it is established under religious endowments like gurukulas, and like your madrasas, okay, like your madrasas and gurukulas. Okay, here religious instructions must follow. Religious instructions must follow. So any religious endowments, any institution established under religious endowments, okay, they must follow the religious instruction. Best example, madrasas. Best example, Gurukulas. Okay, these are the best examples. So this is what the freedom of religious instructions in the educational institutions. Okay, and let us move to the next one. Let us move to the next one. This article talks about, okay, cultural and educational rights to minorities. Cultural and educational rights to minorities. Cultural and educational rights to minorities, Article 29 and Article 30. Okay, cultural and educational rights to minorities. Okay, so that you can understand very clearly, the article is self-explanatory. Cultural rights and educational rights. We're talking about cultural rights 29 and educational rights are 30. First of all, who are minorities? Okay, first of all, who are minorities? Minorities are, okay, there are two types of minorities. One is, okay, there are two types of minorities. One is religious minorities and other one is linguistic minorities. Right or wrong? One is religious minorities, other one is linguistic minorities. Okay. A religious minority means, except Hindus, all are minorities. All are which minorities? All are religious minorities. Right or wrong? So Hindus constitute 79.8%. Okay, and remaining communities constitute the all Muslims. Okay, Muslims, Christians, Jews, Sikhs, all this. This is called as religious minorities. Whereas linguistic minorities, linguistic means language base. Okay, this is there in the article 350A and 350B, 350 article related to linguistic minorities. Okay, so linguistic minorities will language-based minorities. For example, our language is, for example, my language is Telugu. Okay, and my mother tongue is Telugu. If I go to Tamil Nadu, I will become linguistic minority there. If Tamilians enter into our state, linguistic minority. Okay, these are things. So our language, so many languages, Urdu. If you go to Tamil Nadu, Kerala, Punjab, or any states, okay, except Jammu and Kashmir, or any states, you will become a linguistic minority. Okay, Jammu and Kashmir official language is Urdu. Okay, so these are the things try to remember. There are two types of minorities. Whoever the minorities are there, any type of minority, the minorities shall have a right to conserve their culture, their script. Okay, their culture, their script, their language, or anything. Okay, every minority, whoever the minority are there. Okay, all those minorities shall have a right to conserve their script, their language, their culture. Okay, so all these things are very, very important. So whoever the minorities, we all belongs to minorities. I belongs to minority in some other state. Whoever the minorities, okay, minorities shall have a right to conserve their culture. Okay, we are all, suppose for example in Telangana, a time of Pongal, in Telangana, time of Pongal, right? Wait 1 second, please. A time of Pongal, many other communities like the okay, the Kerala people celebrating their Onam. Okay, Tamil people this likewise. It means that Keralites or Punjabi, Gujaratis, whoever it may be. So if they are minorities in our state, they can protect their culture, they can protect their script, okay, their language, because so many languages are not there. For example, Lambadi language is not there, Iruka language is not there. Okay, Bo and Karo languages in Andaman Nicobar are already extinct. Okay, and Hindi follows the Devanagari script. Marathi has no script. Okay, no script. Did you able to understand? So you can have you have a right to protect your language. You have a right to protect your script or anything. Okay, your culture, you can protect your culture. Okay, nobody should force us to follow this one or this. So you have a right to culture, because particularly the South Indians wear dhoti paisama. Okay, dhoti paisama. So all these things, the women, the South Indians women wear the sari. This is your culture. We are followers of all this culture. We follow religious cultures. We follow anything we can follow. So that is very, very important here. So one can protect your culture because based on the minority, as well as minorities have a right to establish the educational institutions. Minorities have a right to establish the educational institutions. Okay, Kannada Vidyalaya, Marathi Vidyalaya. Okay, you can have established any educational institutions. Okay, even the Urdu establishments. So this is Article 29 and 30. Nothing else, not to worry about this article. Just remember, minorities shall have a cultural and educational rights. Okay, minorities have a right to establish educational institutions anywhere. If you go to the Tamil Nadu or Kerala or any other Madhya Pradesh or Rajasthan, you can establish there the Telugu institution, you can establish the Urdu institution. It's your wish. Okay, but a university can put some qualifications. Education institution, simply you cannot put education institution without qualification. You must have a qualification for a senior lecturer post or junior lecturer post, whoever it may be. There must be some qualification. Okay, so qualification should be established by the universities. According to those universities, okay, whichever university you are recognizing, those universities, the qualifications are important, right or wrong? For to teach an intermediate, okay, he must be a PG. To teach a degree, he must be a PG lecture. The qualification is essential. All those all should fulfill the qualification that is set up by the universities. Okay, right. So let us move to the. Somebody asked me the question, sir, what is this Article 31? I told you Article 31 is right to right to property. Okay, right to property repeal. Right to property repeal. Right to property repeal. Which amendment? 44th Amendment 1978. And moved to which article? 300A. And made it as legal right. The question arises, why the right to property repeal? Because the government doesn't have a power to give property to each and every citizen. Okay, it's not possible the government to give the each and every citizen about the property right. So that's the reason. And if you want to claim the property, you must claim legally. Legally, you must claim the property. So, okay, so that's the reason the government moved it from this part to moved it to part 12 of the Constitution, that is financial relations. Their article inserted in the Article 300A. So this is a right to property. Simple. The government cannot give property to each and every citizen. So that's the reason right to property is repealed. But here, but very important, but Article 31A, 31B, 31C also there. Okay, acquisition of estates. Okay, acquisition of estates, implementation of DPSP. So these are the articles is still there. 31 is repealed, 31A, B, C there. Okay, this article talks about the acquisition of estates. Whoever having the estates can be acquisition by the state. The state can be acquired your estate. Okay. Okay. The next one is implementation of DPSP. The Directive Principal Articles. This is the we'll discuss the DPSP. Okay. Implementation of the DPSP. Okay. DPSP articles can be implemented. 31B talks about saving of laws. Saving of laws means whatever the laws made by the legislature. Okay. Whatever the laws made by the legislature, that law will be saved here in the 9th schedule. We'll discuss later about this 9th schedule. But try to remember 31 is repeal. Okay, saving of laws, acquisition of estates and DPSP, implementation of DPSP is still there. Okay, just after reading the complete constitution, you go through these articles. If you have any doubts, so please bring it to my notice. I will discuss there later. Okay. Okay, after completion of this class, I will repeat each and everything. Please be patient. right? Let us move to the Article 32, the last articles of the. Okay, this article talks about the writs. Very, very important. Please listen carefully. This is a very, very important article. Writs will be issued by Supreme Court. Okay, writs. I'm going to tell you Article 32. This is called as the heart and soul of the Constitution. This is called as the heart and soul of the Constitution. Why it is called as heart and soul of the Constitution? This is said by Dr. B.R. Ambedkar. Okay, Ambedkar mentions it is as the, because if any right is not implemented, you can move directly to the Supreme Court for its enforceable. This is called as justiciable. Justiciable means any citizen, okay, any citizen, if fundamental rights are violated, you can move directly to Supreme Court. Supreme Court, according to Article 32, issues the writs. Issues the writ. Pronunciation is writ. Spelling is W-R-I-T-S. Okay, writ, very, very important. The concept of writ is very, very important. Okay, if your rights are violated, this is what? Enforcement of fundamental rights is important. If any state is violating on fundamental rights, Supreme Court to Article 32 and the same High Court in the Article 226 issues the writs. But there is a difference between the High Court and Supreme Court writs. We'll discuss that in the High Court articles. Okay, but here try to understand issuing of writs by the Supreme Court is a very, very important. And that's the reason the main function of the Supreme Court is to protect the fundamental rights of citizens. What is the main function of the Supreme Court? The main function of the Supreme Court is to protect the fundamental rights. Try to remember this one. Okay, this is very, very important. So what is the main objective of the Supreme Court? The main objective of the Supreme Court is to protect the fundamental rights. That's it. Okay, not clearing the cases, not giving the bail order, nothing. To protect the fundamental rights of citizen is the main function, the primary function of the Supreme Court. And according to Article 32, Supreme Court issues writs. Okay, Supreme Court issues writs according to Article 32. So how many types of writs are there? Okay, there are 32 clause 1 says that there are 5 types of writs are there. Okay, the first one is habeas corpus. The first one is habeas corpus. The second one is mandamus. The third one is prohibition. The fourth one is certiorari. The fifth one is quo warranto. These are all the Latin terms and very, very important. Please listen carefully. Right? Habeas corpus. Habeas corpus means just now we discussed Article 22. Arrested person must produce nearby magistrate within 24 hours. This is called as, okay, habeas corpus means called as produce the body. Okay, produce the body within how many hours? Okay, produce the body within 24 hours. Okay, produce the body within 24 hours. This is very, very important. Okay, habeas corpus means suppose if police personnel arrested any one of your friend or anybody, if he is not produced in a nearby magistrate within 24 hours, you can file a writ petition, even the Supreme Court. Article 32. Supreme Court, which writ petition? The writ petition is habeas corpus. According to the habeas corpus, Supreme Court issues order to the concerned DGP or concerned police official to produce that person within 24 hours. Okay, so this is habeas means produce, corpus means produce. If he is dead, the death certificate is to be provided. to the magistrate. So this is very, very important. No person should be detained. If a person is detained or arrested, he must be produced within 24 hours. Okay, 24 hours time will be given. If it is not produced, you can go directly to the Supreme Court. Even the High Court also you can go, Supreme Court also you can go. This is called as a habeas corpus. The second one is mandamus. The second one is mandamus. Okay, the second one is mandamus. So what is meaning of mandamus? Mandamus means we command. Mandamus means we command. Okay, we command. We command means we order. We order you. I'm ordering you. So what is meaning of mandamus? So listen this term, mandamus, we command. So for the public official, say example for the public official. Sir, if a public official is not performing his duty, say example, I would like to tell you one example. If you go to the police station and the police personnel is not registered the FIR, then you can file mandamus in the High Court or Supreme Court. Supreme Court Article 32, High Court Article 226. Okay. So public official, whenever any public official is not performing a duty, the court asks them to perform the duty by petition mandamus, commanding. The court will command you. After becoming you an employee also, if you become an employee, say example, if you become a pollution control board, if you are employee of the pollution control board, okay, many industries are affiliating, affiliates are in the air pollution, they are damaging the air, they damage the land pollution. So what are necessary action to be taken by the pollution control board is to control it. You can file, if it is not controlled, you can file directly in the Supreme Court that so and so public official is not performing a duty. It means that you are starting the public official to perform the duty because he is not performing the duty. Any public official or quasi-judicial body, whatever it may be. Mandamus means the government organization whose duty is to be fulfilled. It is not fulfilled, it is not carrying the duties, obviously, then you have a right to move to the courts for enforcement of this, for the implementation, for the kickstart of this, for to remember the duty of that so it's a public official. By that we can order this one mandamus. Mandamus means we command. The court will command you, public official, to perform your duty because it is your duty, you are not performing. Okay, this is the mandamus. The third one, prohibition. The third one is prohibition means simply prohibition means to stop or to restrain. To stop or to restrain. Okay, to stop or to restrain. Usually, the higher courts ask the lower courts, order the lower courts to stop or not to take this case. Initially itself, no case should be taken up here. Any lower courts directly, the case will be moved to the upper courts itself. That is called as to stop or restrain. Simply, prohibition means prohibited. You are not allowed to take up that case. Okay, this is called as a prohibition, to stop at initial stages. For example, regarding the NEET examination, I'm telling regularly this example. Regarding the NEET examination, so many cases filed in the different high courts as well as the Supreme Court. Supreme Court says that all the NEET related cases should not be taken up here. Only the Supreme Court will deal the case, and no high court is allowed to take the NEET related examination, any examination cases. So when the Supreme Court says this one, this is called as a prohibition. Okay. And the fourth one, certiorari. Certiorari means to be certified. To be certified. To be certified means here the court certifies that, here the court, higher court certifies the lower court, okay, you are exceeding your limits, stop it. You are exceeding your limits. This is to certify that you are exceeding your limits. You should not cross your limits. This is not your purview. Okay, in the middle of the case, the court asks the lower courts that you are exceeding your jurisdiction. This is not comes under jurisdiction. So please, it means that the court certiorari to the lower court to move to the case to the higher court. This is called as the certiorari. And the last one, quo warranto. Quo warranto means by what authority? By what authority? By what authority? Quo warranto. By what authority? By what authority means, it means that by what authority means, suppose a public official, the government allocates the quarters to the public official or public servant or the political official, whoever it may be. So let's take the example of the any MP quarters or MLA quarters. Okay, the government allocates MP quarters to the current MPs, present MPs. Okay, current MPs. After losing his membership, it means that after completion of the tenure, okay, the ex-MP should not be, the former MP should not be reside in that quarters. The quarters is meant for the serving MP, the present MPs. Right or wrong? Right or wrong? So here, if any MP, even though he is not a member presently, he should not be stayed or reside in that quarters. If he is reside, you can move to the court, Supreme Court, and file a writ petition of quo warranto. By what authority you are staying there? By what authority? It means that this quarters is meant for so and so MPs, so and so ministers, or so and so MLAs. You are not an MP, you are ex-MP, you are not a minister, you are ex-minister, you are not an MLA also. So these quarters are meant for the present MPs, present MLAs only. Why? Why you are residing? By what authority you are residing? This is called as quo warranto. This is called as quo warranto. Okay, so I'm repeating this one. Habeas corpus produce the body, mandamus, command, prohibition, stop, seditiary, certified. Quo warranto means by what authority? And finally, sir, what is this next article talks about? 33, 34, 35. Okay, the fundamental rights 33, 34, 35. These are the restrictions, modification. These are the restrictions, modifications of fundamental rights. Okay. Restrictions, modification, implementation of martial law. Okay, this is nothing but whenever the martial law is implemented, fundamental rights can be restricted. The fundamental rights can be modified. The fundamental rights is not applicable to the armed forces, right or wrong? Okay, all these things. Suppose any even 144 section is implemented, the fundamental rights is not applicable. The fundamental rights can be suspended, can be modified. So all these things are rated, not much important here. Okay, not much important here. Okay, 33, 34, 35. Right? Clear all of you? Okay, right. Okay, right. So we had completed in the today's class. We had completed the fundamental rights. We had completed the fundamental rights. So, any questions? Any doubts? I will allow you to discuss all these questions. Just please wait for 1 minute. Right. Right. So I'm checking. You can ask me doubts now. You can ask me doubts now. Okay. I have quick opinion to share. So far, everything is going good. Like all the teachers who have taken classes on topics are simply amazing, and explanation is also slow. And understandable, but as a student, as we are habituated to refer textbooks before and after attend the class too. Yes, you must refer. Okay, you must refer any textbook. Okay, Rahmatunnisa. You can refer. I told you that. Lakshmikant Polity is one of the good textbook, or else you can download some important NCERT textbooks. The app is also so many app is also there. Okay, so many app is also there. You can download from internet also. Okay, soft copy or hard copy of materials and all topics. Yes, soft copy is there, but it is not updated. So that's the reason. That's the reason I'm not giving the soft copy. Okay. Okay, soft copy at present is a very old one. I'll try once I get the new updated soft copy, I'll try to provide it. Okay, how many articles are there? I told you a lot of times that is they are numbered 395 numbered articles, and number of articles is more than 470. Okay, right. I'm telling you, this subject is useful to each and every examination, right? Each and every examination, quality up to UPSC level, up to UPSC level. Okay. So under normal circumstances, we cannot take away the fundamental rights, but only at the extraordinary circumstances, likewise the national emergency, implementation of national emergency. At the time of national emergency, the fundamental rights can be taken away, can be suspended, anything else. Okay. Yeah, I told you that Lakshmikant, Indian Polity Lakshmikant is one of the good book, Rahmatunisa. Okay, thank you very much. Can you unmute? Okay, unmute. Allow participant to unmute yourself. Please wait. Okay. I had unmuted just now. You can talk now. Article 20 says that. I think you attended very late today, Juveria. Okay.
Yes, sir. Sorry for the late.
Article 20 says that no ex post facto legislation, no double jeopardy, and no testimonial compulsion. It means that whenever the law made, it is applicable from the assent, not from the backdated. Okay, from the assent, not from the backdated. This is the no backdated. That is called as no ex post facto legislation, as well as no double jeopardy. It means that no double punishments. All the punishments will be implemented simultaneously. Suppose if a person convicted for 4 to 5 sections, all those 4 to 5 sections punishments will be implemented simultaneously. Okay, that is no double punishments. Whereas the third one, no testimonial compulsion, or no self-incrimination. It means that no person shall be compelled to do his witness or his or her witness. Suppose you know that I'm not committed a mistake. Okay, I'm not committed a mistake, but I will not compel you to come and to be a witness. This is Article 20 says that. As well as the police personnel should not collect the fingerprints, should not compel the accused to do sign here, should not take the fingerprints forcibly. This is also comes under Article 20, Clause 3. You please watch my video again. If you have any doubts, okay, starting it will be uploaded at the night. If you have any doubts, we'll discuss them in the tomorrow's class. Okay, Juveria? Right.
Okay, sir. Article
I'm
27.
not able to hear properly. Please be louder. Just 1 second.
Hello.
Yeah.
Article 27. It's freedom not to pay taxes. Like, sir, if it is a trust for the help or will provide to help the needy people to give
Okay.
money or whatever, clothes and all. So for that also, for trust and all also, we have to pay the taxes.
Yeah. We're talking about the religious only. The trust is entirely different. If you donate some money or anything to the trust, that is exempted under the taxation. That is the provision is there. Suppose if you donate for 5,000 or 10,000 to any trust, that you can exempted under the 18 clause C or something. In income tax exemption is there. That is entirely different. I'm talking about the religious here. This article talks about the religious. So in the religious institution, the government should not take it up or should not collect the taxes. Okay.
Okay.
Did you understand? Is it clear?
Yes, sir. And one more, sir, in Article 22, nowadays most of the people they are living in a different country, and divorce cases are being increased. They are being there, and they are sending some notices and all or whatever. So regarding the arrest and warrant. So
Okay.
nowadays it's been too late. So most of the cases which I heard and read it in the newspaper, uh, so what about the people who are staying in the different country? They cannot come within a 24 hours, right?
No, 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 no. Okay, okay. You please continue. I will clear your doubt.
So it's like, if might be even you have studied, I guess, I don't have any idea, but the people, those who are living in the different country, the FIR has been booked, and the documents which they have signed and given a divorce notices from different country, and the girls and the women are facing here in India, they are taking lots of even the police and all, and no one is taking like any action. And regarding the consult to the lawyer, even those they are, it's been so delayed and all. So what about that?
Yeah, for that, okay. If you're talking
They cannot,
about,
like, they cannot
yeah,
come in a 24 hours, right?
no, 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 no,
To
no. Yeah, yeah. That is very different. Here, whoever the person arrested, Article 22 clearly says that whoever the person arrested, the arrested person must produce within 24 hours, not the person who is facing FIR, who is having the case of FIR, who left the country. That is not related here. This is related here. Those who are arrested, the arrested person, okay, within 24 hours, he or she must produce nearby magistrate. Not I am talking about the persons who are not yet arrested. This is after getting arrested. Suppose you're talking about regarding the divorce cases or anything cases, any DBC cases or any cases, one who left the country, okay, one who left the country, the police personnel will try to catch that person. Will try to go there, and extradition treaties will go there and try to bring that person. The best example, Abu Salam. I told you the Abu Salam, okay, the Abu Salam, the present police commissioner, Hyderabad police commissioner CV Anand, he went to Portuguese and he arrested Abu Salam, and after entering into the India, within 24 hours, nearby magistrate, he produced the nearby magistrate. So this is we are talking about. FIR registered or the accused is not the matter here. After any person getting arrested, okay, any person is in the police custody, within 24 hours, the arrested person must be produced near magistrate. This is important here. Need to understand, Juveria?
yes, sir, but most of the cases are coming like the accused is in, like, example, he is in USA or Canada, Australia, wherever. So the girl is in India and they have sent a notice and all those kind of thing regarding
Yeah,
whatever children's and all
yeah,
divorce case. So if they go and charge the FIRs and all, so
okay.
how that accused person can be come back to India?
Yeah, this is through proper channel. This is through proper channel because so many people left India and settled in different parts of the country, and so many people are facing the domestic violence cases or 498 cases, dowry cases. So many people are facing so many
Yeah,
accusers
yeah.
are there. But here, one thing is very important: the government will take proper action through proper channel. It means that concerned embassy should be, first of all, our embassy and that country embassy should be, Indian embassy is also there in that country. Through proper channel, our embassy will send a notice to that embassy, and in that embassy, wherever the accused person is there, first of all, they will try to catch that accused person. They will take it into their custody. After into their custody, our Indian people, our Indian police personnel go to that concerned police personnel will go to that location and catch that person and bring it to the Indian jurisdiction. This is the process, but it will
Okay.
take some time. It will take some. It's not an easy one. First of all, where is that person, and the concerned country also should accept to arrest that person. Okay. So best example I told you Abu Salam. Abu Salam, India, Portuguese made an extradition treaty. Extradition treaty means the criminal transfers from one country to another country, criminal transfers. Okay. So that's the reason Abu Salam got arrested in UK, in Portuguese. From there, Indian authorities went to Portuguese and and brought that Abu Salam India, and as per Indian law follows.
Can't we stop them from India to like not extending their passports and all, like
Yeah,
giving
we can
letters
do.
and all
Yeah,
through?
at least the government can take necessary action. Suppose if a person is trying to move out of the country and their passport will be seized, a passport will be seized in they once they put the restricted mode or prohibited mode, so they can take necessary action if it is a person is trying to move out of from India. Okay.
In after all this, how many months or days the person will be arrested?
It will take some time. We
Like
can't
like,
say, yeah, we
like it
can't say
will.
exactly. We can't say exactly how much time will be taken by the government. We can't say exactly because we don't know whether a person is in India or foreign. If it is escaped to the foreign, whether he is a person in that country or not, the concerned authorities must give permission to arrest that person. It will take some time. It depends upon the country to country. It will take some time.
It should be like it should be from court, right?
Yeah, the court should give
Okay.
orders to the concerned court should give orders, or the concerned embassy or the government should take necessary action. So all of a sudden it is not possible. It will take some time. The time process. The court can give orders to the concerned police authorities to catch that person or to ask the embassies to catch that person and bring it here. Likewise happens, but it will take some time. It's not that much easy.
Okay. Okay, sir.
Okay, thank you very much.
Thank you.
Yeah, all of you, I suggest you to all of you, videos are uploading. Videos are uploading in this minority study circle. You can watch those videos there daily at the evening. I think that's the evening. It is uploading in the evening. Also, Max, yes sir, Max is also all subjects is there. How many subjects do we study in minority study? All subjects, all related subjects. You can go through the minority study circle video. Okay, please search in the YouTube minority study circle. Okay, any questions, any doubts? So anybody preparing for the UPSC examination? UPSC, because UPSC examination in the month of June.
June 5th.
Yeah, June 5th. Okay.
Yes, sir. Okay, sir. Can you say me once again? Explain me about Keshwananda Bharti case of Kerala.
Okay. Okay. I told you Keshwananda Bharti case is in property related, religious property related case. Keshwananda Bharti case according to Article 26 Clause C. Okay. Anybody acquiring of movable and immovable properties. Okay. But the Kerala state implemented land reforms. Okay, land reforms means important land sealing act is also there, and they had possessed all the religious assets of the Keshwanda Bharti that is challenged in the court of law. As per 26 clause C, religious institutions can acquire movable or immovable properties. This is what the case related to it. As I suggest you not to go into depth about the case is related to meant for the acquiring the properties of the religious institutions. Okay.
Okay, fine.
Any questions? Any doubts?
Sir, good afternoon, sir.
Good afternoon, Sheikh Mohsin.
Sir, myself Sheikh Mohsin, sir.
Yeah. अभी देखा आपके नाम बोलो भाई.
Sir, can you have any kind of PDFs?
Yeah, actually, that is what PDF is old one. I have not updated. So there are so many corrections are there in the PDF. I will try to provide whenever I will get the new PDF. Okay, new PDF.
Okay.
New PDF. It is a very old 2018 notes I have not yet updated. There are so many mistakes are there in that PDF itself. Just for reference sake, in the first two sessions, in the reference sake, I had shown to you, but it's not at all complete because there are so many updates. After 2018, there are so many updates because constitutional amendments, so many articles were added, so many acts were added. So my suggestion is to all of you go through the standard textbook, and if at all any new PDF is available, that I will provide. No
Okay,
problem.
okay, sir.
Okay, Musin.
Okay, sir. Thank you.
Any questions? Any doubts? Shall we call it today?
Okay,
Yes,
sir.
sir. Thank
Yeah.
you.
Thank
Okay,
you.
sir. Thank you.
Thank you very much. If you have any doubts, all of you, I suggest you to all of you.
Thank you, sir.
Please read it. Please try to revise it. Tomorrow's subject is DPSP, Part 4 of the Constitution. Okay, Part 4 of the Constitution. Tomorrow's topic is DPSP, Part 4 of the Constitution. So all of you try to read it. Try to read it from. So anyhow, you're using internet. You know the different sources are available in the internet. So try to have at least have a glance of DPSP articles. Okay, Article 36 to Article 51, Directive Principles of State Policy. So from daily every 2 hours, we'll try to finish it off. Okay, we'll try to finish it off the subject. Okay, this is very basic and foundation, but I suggest you to all of you go through the before attending these classes. At least try to prepare yourself. At least try to have that glance. So which topic is tomorrow's topic is DPSP, or else try to complete, try to revise what we had completed so far. What we had completed so far. So far we have completed 3 parts. Is that or wrong? Part 1, Part 2, and Part 3. Okay, the 3 parts we have completed, right? So likewise, try to improve your subject. Likewise, try to improve your subject. Clear, all of you? Right? So still, any questions, any doubts? 2 to 3 minutes. Any questions, any doubts?
Excuse me, sir.
Haji.
Sir, did you have any kind of separate channels of yourself?
No.
Escape this minority study.
Minority and BC study circle. Only 2 study circles have this. I'm teaching polity there. But whereas I have videos of private institution, but private institution you will not get access to there because it is completely payment. And BC study circle, and this one is totally free. Okay.
Okay, sir. Okay, thank you.
Yeah, I'm going to teach only one subject here, not more than one subject. Okay, I'm going to teach only polity. Okay, one subject, one lecture, one subject. Okay, I think it's enough. Otherwise, we'll get bored by looking at face continuously. By teaching 3 or 4 subjects, we'll get bored. So I can teach different subjects, but it's not necessary here to teach all those subjects. Only one polity is enough. Okay, Saif? Right.
Sir, Vishaka versus state of Rajasthan, is that important?
Yeah, it's very, very important. Vishaka versus state of Rajasthan is 100% important. In the group 2 level examination also question came. One question came in the group 2 level examination. Question is that according to which judgment sexual harassment of women at working places are prohibited? The answer is Vishaka versus state of Rajasthan. So Vishaka versus state of Rajasthan violates the article 15, 21 and 23 articles. Very, very important. So based on Vishaka versus state of Rajasthan, the government of India enacted that law. I told you the prevention of sexual harassments of working places are prohibited. Okay, prohibition of sexual harassment of working places are prohibited. So 2013 Act is also there. Please go through that Act. Please go through that Act. Okay, you can type here. You can type in the internet that is prohibition of sexual harassment at working places. Okay, so that Act is very important for the UPS level examination also.
Okay, sir.
So there, at least I suggest you to in the polity subject, at least 20 to 25 case studies are important. 20 to 25 case studies. Minimum of 20-25 case studies is very important, and nearly 7 to 8 doctrines are important. Doctrines. I told you doctrine of eclipse, doctrine of severability, doctrine of waiver, right? So such doctrines are also very important. Okay. So please watch my videos regularly. If you have any doubt, to bring it my notice in the tomorrow's class. We'll discuss all those things. Right?
Yes, sir. Thank you.
Shall we conclude?
Yes, sir.
Okay, sir.
Okay, thank you very much. We'll meet at tomorrow 10 o'clock. Don't forget, you must get ready at time of 10 o'clock itself, 10 to 12 only. Okay, today I started at 10:05. I'm ending at 12:30 right now, but 10 o'clock is the time to start. Okay, sharp 10 to 12. Okay, don't forget. Come online, try to attend this session online, because you have some interaction sessions here. Otherwise, it's very difficult to ask the questions. Any doubts also? Clear?
Yes,
Okay, sir.
Yeah, thank you.
Okay, Mutasabit. Okay, right.
Yes, sir.
So we'll meet. One thing I would like to ask you for the question: how many of you are graduate qualified? Or is there any intermediate qualification? Is there? Those who are in online now, 16 participants. Inter qualification. How many of you are inter qualification? Graduated. Okay. So all are graduates.
Yes, sir. Software engineer.
अरे भाई सॉफ्टवेयर मत बोलो, ग्रेजुएट बोल के बोलो बस फिर.
Okay, sir.
Graduate engineer. Okay, graduates, because okay, graduate is enough. I mean that if you are completed degree, you can write different types of examination. Intermediate level, you can write the police constable examination, or degree level, you can write a sub-inspector examination, right? Okay. Very few are inter qualification, majority are graduates. Okay, right. Thank you very much. Tomorrow we'll be meeting at sharp 10 o'clock. And my suggestion is, all of you, if you are having free time, continue your preparation like this only. So up to 1 o'clock or 2 o'clock after lunch also, you continue this subject. Okay, continue this subject. Okay. And if you have any doubts, okay, if you have any doubts, you can please contact me also on my phone number. I can provide you my phone number also. If you have any doubts, sir, I have this doubt and this doubt also, I can provide you my phone number, so that you can ask me any queries about your polity doubts. Tomorrow's class, I can clear your doubts. Okay, you please note down my phone number: 9849118530.
Sir, can you write on your phone number on whiteboard?
Yeah. Right. Bye. Right. Okay. Thank you very much. So those who are serious candidates, those who are very much serious in preparation, you can ask me the doubts related to the subject only. You can message me about this subject only. Okay. Apart from this, it means that don't ask me the other things apart from subject. I can't able to clear your doubts because I don't have much time. So please be restricted with the subject, and whatever you have doubts with the preparation, your examination preparation also. So I want to prepare this examination, I want to go to this examination. Okay. So my name is Ravi Shankar, D. Ravi Shankar. My name is D. Ravi Shankar. Okay. So if you want to prepare for any examination, so here I will guide you, because from the last 4 to 5 years I am teaching in the minority study circle. Your seniors and majority of the seniors are preparing for different examination. Even I guide them to prepare for the UPS level examination also. Okay, they are still in contact with me. So many boys, they are calling me, sir, I want to prepare this exam, I want to prepare that exam. So whatever the help from my side, I will definitely suggest you to have a awareness about the examination, because I had done my UPS interview. I wrote group 1 mains 5 times, Even APPS examination also I wrote. So this is what I'm telling you because I have knowledge about the competitive examination. Here for the SSC, Staff Selection Commission, now I'm teaching UPSC mains and Group 1, Group 2, Sub Inspector, Police Constable I'm teaching. So that's the reason I'm telling you, if you have any, because so many students are asking for the different examinations. So I'm preparing for SSC. Somebody messaged me that is it useful for SSC, Constable, everything. Any examination, polity subject is very important. So from my side, from any help, I will sincerely help you. Okay, thank you very much. Tomorrow we'll meet at 10 o'clock. Kindly attend at 10 o'clock. Separate class means, okay, we'll separate class means if I have time, I will take separate class. Okay. Okay, Juveria, will discuss if it is possible, then I will take, otherwise it's maybe a bit, depends upon the time. Okay, so as of now, try to attend this class, ask your friends to attend this class regularly. Ask them to come live session because we have some interactions there, so you can clear your doubts itself. Okay, right? Thank you very much. You please tomorrow try to prepare with the DPSP part, Director Principles of State Policy. Okay, Director Principles of State Policy will discuss. Okay, right. So thank you very much. You can tomorrow. Yes, yeah. I will give you. I will guide you all the examination. No problem. Okay. Right. Thank you very much. We'll meet tomorrow.